Hi everyone and welcome back. Now today we are going to discuss a very important and often misunderstood concept in the constitutional and administrative law. The distinction between judicial and quasi-judicial functions in India. Now this topic is something that's very extremely relevant, not just from the exams perspective, but also for practical legal understanding because in India, justice is not delivered only through courts. There are several uh, authorities, tribunals that perform functions which are similar to courts but are not strictly courts. So today we will understand what exactly is a judicial function, what is a quasi-judicial function, what are the constitutional provisions behind them, why such a distinction exists, and the key interpretations for the same. So let's begin with what exactly is a judicial function. A judicial function often refers to the power exercised by the courts to interpret laws, adjudicate disputes, and to deliver binding decisions. In India, judicial powers are vested in courts under the Constitution. The primary constitutional provisions include your Article 32, which gives you the right to constitutional remedies, Article 136, which gives your SLPs or your special leave petitions, Article 226, writ jurisdiction of High Court, Article 141, that is law declared by the Supreme Court, is binding. Now, the purpose of these provisions or these articles were basically introduced for ensuring the protection of fundamental rights, uniformity in legal interpretation, and to ensure there was access to justice. Now, Dr. Ambedkar described Article 32 as the heart and soul of the Constitution, emphasizing its importance. The key characteristics of the judicial functions are performed by the courts based on very strict legal procedures, and the decisions are binding and enforceable. They have to, the courts or any quasi judicial body has to follow the basic principles of natural justice. Now, what exactly is a quasi judicial function? Now, a quasi judicial function, it refers to powers which are exercised by administrative or executive authorities that require them to determine the facts, apply legal principles, and make decisions affecting the rights. However, they are not fully fledged courts. Now, examples are your tribunals, your regulatory authorities, tax authorities. These bodies are created to ensure faster dispute resolution. They are specialized expertise and they exist to reduce the burdens of the court. Now, the constitutional basis for tribunal comes from Article 323A, which is administrative tribunal, Article 323B, which is tribunal for other matters. Now, these provisions were introduced in India through Constitutional Amendment Act of 1976. Now, the whole purpose of this act is to increase speedy justice, to take care of your technical adjudication, to reduce the court backlog. So let's talk about what is the new requirement or the need for quasi-judicial bodies. Now, the need for quasi-judicial body or why exactly did India create quasi-judicial body? The answer, it lies in increasing complexity of the governance because there has been a huge rise in the administrative decisions. There is judiciary which is completely overburdened. We all know the backlog of cases, the number of cases that are pending. For example, your taxation, corporate regulation, and service matters, they require a lot of technical expertise. Now, a regular court may not be always the most efficient forum in such a case. So, therefore, in order to bridge this gap, there is a quasi-judicial body which takes care of executive action and also the judicial oversight. Now, let us understand the distinction between judicial and quasi-judicial functions. Your nature of authority. Let's begin with that. In judicial functions, it is exercised by courts like the Supreme Court and High Court. Quasi-judicial, it is basically exercised by the administrative bodies or tribunal. Let's talk about source of power. Your judicial source of power, it comes directly from the Constitution. Quasi-judicial, it comes from statutes or constitutional provisions like Article 323A or Article 323B. Your procedure, your judicial procedures, your judiciary procedures, you have strict compliance of CPC and CRPC, and hence it takes a long duration to settle these cases. Quasi-judicial, they have flexible procedures, but they must follow the principles of natural justice. So if you see an arbitration, mediation, or a conciliation procedure, CPC and CRPC is not something that is strictly followed. Even Evidence Act, for that matter, it's not that binding for a quasi-judicial procedure. Let's talk about the independence. Judiciary is something that's completely independent. Quasi-judicial may have an administrative control, but they need to act very fairly. The nature of decision, the decision of the judiciary is final and binding. It is subject to appeal. Quasi-judicial, it is binding, but it is again subject to judicial review. Now, when you talk about all judicial functions, they are adjudicated, but not all adjudicatory functions are judicial. Some are quasi-judicial. Let's come down to my favorite topic of principles of natural justice. Now, both your judicial and quasi-judicial bodies, they must follow the principles of natural justice. Principles of natural justice include audi alteram partem, that is here the other side, and nemo judic, no one should be a judge in their own cause. The whole purpose of this particular act is to ensure fairness, transparency, and accountability. Even quasi-judicial authorities are bound by these principles. Let's talk about the landmark judgments. So we'll go back to Province of Bombay versus Kushaldas Advani. This case, it clarified the distinction between your administrative and quasi-judicial function. The court held that a quasi-judicial act, it requires a duty to act judicially. A.K. Kripak versus Union of India. Now, this is a landmark judgment that we have all studied in our constitutional law. The Supreme Court clearly blurred the distinction between administrative and quasi-judicial functions. It even held that administrative actions must follow the principles of natural justice. Menka Gandhi versus Union of India, this case, it expanded the scope of fairness under Article 21. It emphasized that procedure, it should be just, fair, and reasonable. Now, these cases, they show the line between judicial and quasi-judicial is not that rigid. It evolves with the constitutional interpretation. Now, one of the most important safeguards is judicial review under Article 32 and Article 226. Courts can review decisions of quasi-judicial bodies. The whole purpose of having courts to review these quasi-judicial bodies is to prevent misuse of power, to ensure the legality, and to protect the fundamental rights. So, in order to conclude, judicial and quasi-judicial functions are both essential in India's legal system. Judicial bodies, they ensure constitutional supremacy. Quasi-judicial bodies always ensure efficient governance. The duty of the Constitution is to create a balance between rule of law and administrative efficiency. And this balance is what exactly keeps the system more functional. So if you found this session helpful, do share it with your friends and fellow law students. Let me know in the comment, do you think tribunals should have more independence? I'll see you in the next session. Thank you so much.